Hello friends, you are welcome once again. Today we are going to solve some more MCQs of Evidence Act. Earlier we have finished up to 55 number of the question. Now we are going to question number 56. Let's see. Under section 45 of Evidence Act, the opinion of expert can be for A. Identity of handwriting, B. Identity of finger impression, C. Both A and B, D. Neither A nor B. The correct answer is the both A and B. Question number 57. Under section 45 of the Evidence Act, opinion of expert can be on the question of A. Indian law, B. Foreign law, C. Both A and B, and D. Only A and not B. Now the question answer is the B, foreign law. '58. Opinion of expert under section 45 Evidence Act is a conclusive proof, is not a conclusive proof, is a supportive and corroborative in nature, and D either A or C. Correct answer is the C, is supportive and corroborative in nature. 59. The disputed handwriting can be proved. A. By calling an expert. B. By examining a person acquainted with handwriting of the writer of the question document. C. By comparison of the two admitted and disputed handwriting, and D. All the above. The right answer is the all the above. The 60. Res inter alia acta is receivable under section 45, 46, 47, 48. So it is the B section 46. Now the 61. Entries in the book of accounts regularly kept in course of business are admissible under section 34 of Evidence Act. Options are A. If they by themselves create a liability. B. If they by themselves do not create a liability. C. Irrespective of whether they themselves create a liability or not. D. Either A or B. The right answer is the C. Irrespective of whether by themselves create a liability or not. 62. When the court has to ascertain the relationship between one person, the opinion of any person having a special means of knowledge and expressed by the conduct is admissible under section 51, B under section 50, C under section 52, and D under section 49. Right answer is the under section 50 of Evidence Act. Question number 63. Relationship of section 50 of Evidence Act means relationship by blood only, relationship by blood or marriage. C. Relationship by blood or marriage or adoption, and D. Only A and not B and C. Right answer is the relationship by blood or marriage or adoption. It means that it includes all kind of the relationship. Now the question number 64. Opinion as to marriage under section 50 of CPC. Let's see. Options: A. Admissible in case of offense against marriage. B. Admissible in proceeding under Indian Divorce Act. C. Admissible both A and B. D. Neither admissible in case of offense against marriage nor in proceeding under Indian Divorce Act. So right answer is the D. Question number 65. The proposition under Evidence Act are there are some conditions and there are later some options. So let's see some conditions. There are 4 conditions. 65. The proposition under Evidence Act are: 1. In civil cases, character evidence is admissible unless the character of party is fact in issue. 2. In criminal cases, the evidence of good character is admissible generally. In criminal proceeding, evidence of bad character is inadmissible unless the same is a fact in issue. And 4. In criminal proceeding, evidence of bad character is admissible when evidence of the good character has been given. Now, in relation of the above position, which of the following is correct? We have to choose correct out of the 4. So the right answer is the, I'm not telling the option, I'm just telling the right answer because all the condition I have read for you already. The right answer is the all the four are correct. Okay, all the 4 are correct. Now the question number 66. Fact of which the judicial notice is to be taken are stated in section 56, 57, 58 or 55 of Evidence Act. So right answer is the section 57 of the Evidence Act. Now question number 67. List of the fact of which the judicial notice has to be taken under section 57 of Evidence Act is exhaustive, is illustrative, is both A and B, is neither A nor B. Answer is the B, is illustrative only. 68. Fact which need not to be proved by parties include A. The fact of which the judicial notice has to be taken. B. The fact which have been admitted by the parties at or before the hearing. C. Both A and B. And D. Neither A nor B. The right answer is the C. Both A and B. 69. The court may in its discretion call for proving the fact A. of which judicial notice has to be taken, B. which have been admitted otherwise than admission, C. both A and B, and D. neither A nor B. Right answer is the B, which have been admitted neither than admissions. Now the question number 70. Oral evidence under section 60 of Evidence Act may be A. direct, B. hearsay, C. both A and B, and D. neither A or B. Either A or B. Right answer is the direct only. Now the content of 71. The content of the document under section 59 of the Evidence Act can be proved by oral evidence, B. cannot be proved by oral evidence, may or may not be proved by oral evidence, D. can only be proved by oral evidence under the order of the court. Right answer is they cannot be proved by the oral evidence. Now the question number 72. Contents of a document may be proved under section 61 of the Evidence Act. Options: A. by primary evidence, B. by secondary evidence, C. either by primary or secondary evidence, and D. only by primary evidence, not by secondary evidence. So right answer is the either by primary or the secondary evidence. The secondary evidence of document means the copies of the document, oral account of the content of the document, B. both A and B, and D. only A and not B. The right answer is the both A and B, means copies of the document and oral account of the content of the document. 74. The secondary evidence of the document is admissible as substitute for A. admissible primary evidence, B. inadmissible primary evidence under certain circumstances, C. inadmissible primary evidence under all the circumstances, D. both A and B are correct. The right answer is the admissible primary evidence. 75. The circumstances under which the secondary evidence is admissible have been enumerated in which section? We have total section. Options are A, B, C, D, 63, 64, 65, 66. Right answer is the 65. Secondary evidence is given in 65. 76. Secondary evidence is admissible where the non-production of primary evidence has not been accounted for, B. Where the non-production of the primary evidence B. Where the non-production of the primary evidence has been accounted for. C. Irrespective of whether the non-production of primary evidence has been accounted for or not. D. Both A and C are correct. Right answer is the B, where the non-production of the primary evidence has been accounted for. Now the 77, the oral document 77, the oral account of the content of document is admissible. A. When given by a person who has seen and read the document. B. When given by a person who has seen but not read the document. C. When given by a person to whom the document was read over. When given by any of the above. Answer is the A, when given by a person who has seen and read the document. 78. A document required but to be attested can be proved under the section 68 of Evidence Act only. Options are A. By the calling both the attesting witness, by calling at least one of the attesting witness. C. By calling none of the attesting witness but by calling some other person who has the knowledge of the contents. And D. All the above. Right answer is the B, by the calling at least one of the attesting witness. 79. The calling of at least one attesting witness to prove a document under section 68 is not necessary. A. When the document other than a will is registered under the Indian Registration Act. B. When the document including will is registered under the Indian Registration Act 1908. C. When the document, irrespective of whether it is a will, is registered under the Indian Registration Act 1908. And D. Both B and C. Answer is the A, when the document other than a will is registered under the Indian Registration Act. 80. A will is required to be proved by calling at least one attesting witness. Options: when it is registered. B. When it is unregistered. C. When it is admitted. And D. All of the above. Right answer is the all of the above. 81. Public documents are mentioned in section 72, 73, 74, 75. So right answer is the C, section 74 of the Evidence Act. Now the 82. The content of which are not covered under the section 74 of the Evidence Act. Options: A. Semi-public document. B. Quasi-public document. C. Private document. And D. All the above. Right answer is the C, private document. The maxim omnia prosecutor right as actor means. Let me read it once again for you. It's quite hard to pronounce it correct. Maxim omnia prosecutor right as acta means. So options are: all acts are presumed to be right done, all acts are presumed to be not rightly done. C. All acts are presumed to be wrongly done. And D. All acts are presumed to be not wrongly done. Right answer is D. All acts are presumed to be rightly done. Now the 84. Admissibility of the electronic record has been prescribed under. Options: A. 65, B. 65A, C. 65B, and D. 66. Right answer is the 65B. Now the 85. Principle of the Omnia Prosecutive Right Act is contained in section 78, 79, 80 or 81. Right answer is the section 79. Earlier we have discussed the Omnia Prosecutor Right Hesekesta, which means all acts are presumed to be rightly done. Now the question number 86. Section 79 of the Evidence Act applies to: A. certificates issued by the government officer, B. certified copies issued by the government officer, C. other document duly certified to be genuine by government officer, D. all the above. Now the right answer is the D. all the above. 87. The section 79 of the Evidence Act contains options A. An irrebuttable presumption of law, B. a rebuttable presumption of law, C. a presumption of fact, D. no presumption either of fact or law. Right is the B. a rebuttable presumption of law. 88. Section 79 to 85 of Evidence Act contain A. presumption of facts, B. rebuttable presumption of fact, C. a rebuttable presumption of law, D. irrebuttable presumption of fact. Answer is the B. rebuttable presumption of the law. 89. Presumption as to the accuracy of map and plans made by the authority of government is contained in which section? Options are A. 81, B. 82, C. 83, D. 84. Right answer is the 83. 90. Under the section 83 of the Evidence Act, presumption as to the accuracy of map and plans can be raised in respect of A. maps and plan made by private person, B. maps and plan made by the authority of government, C. both A and B, and D. only A, not B. So it is B. maps made by the authority of government. Now 91. Which of the following section of the Indian Evidence Act to interrogation by custom officer exercising power under section 171 of the C Custom Act? Section 131, B section 132, C section 133, section and D section 134. Right answer is the 132. This section does not apply when there is an interrogation of the custom officer. Now the question number 92. Which of the following is true of the effect of admissions? We have to talk about the admission. Now let me read you. Option number 1. An admission constitutes a substantive piece of evidence in case and for that reason can be relied upon for proving the truth of fact incorporated therein. B. An admission has the effect of shifting the onus of providing to the contrary on the party against whom it is produced, with the result that it casts an imperative duty on the such party to explain it. In the absence of the satisfactory explanation, it is presumed to true. An admission, in order to be competent and to have the value of effect referred to above, should be clear, certain and definite, and not ambiguous, vague to be true. D. all of them. The right answer is the D. all of them. It means the all conditions are satisfied. 93. A intentionally and falsely leads B to believe that a certain land belongs to A, and thereby induces B to buy and pay for it. The land afterward becomes the property of A, and A seeks to set aside the sale on the ground that at the time of the sale he had no title. The applying section 115 Indian Evidence Act. Options: A. He must be allowed to prove his want of title. B. He may be allowed to prove his want of title. C. He must not be allowed to prove his want of title. D. None of them. So right answer is the C. He must not be allowed. 94. A is accused of a crime committed by him at Calcutta. He produces a letter written by himself and dated at Lahore on that day, and bearing the Lahore postmark of that day. Applying section 21 of Evidence Act, which of the following is possible? A. The statement in the date to the letter is admissible because A were dead. It would be admissible under section 27 clause 2. The statement in the date of the letter is admissible because A, if were dead, it would be admissible under section 29 clause 2. C. The statement in the date of the letter is admissible because if A were dead, it would be admissible under section 32 clause 2. D. A statement in the date of the letter is admissible because if A were dead, it would be admissible under section 34 clause 2. Right answer is the C. Now the 95. A. A sculptor agrees to sell to B all my modes and has both model and modeling tools. Applying section 98 Indian Evidence Act. A. Evidence cannot be given to show which he mean to sell. B. Evidence needed not be given to show which he mean to sell. C. Evidence may be given to show which he mean to sell. And D. None of them. C. Evidence can be given. 96. In criminal cases under section 54 of the Evidence Act, to prove that the defendant committed the crime charged, evidence may not be given, but he A. bore a bad reputation in the community, B. has the disposition to commit crime of that kind, C. had no other occasion committed particular act of the same class, evincing each disposition. D. All of them. So friends, right answer is D. All of them. 97. In which of the following proceeding of domestic tribunals and departmental inquiries Indian Evidence Act is not applicable? A. Officer conducting departmental inquiries. B. Departmental proceeding. C. Disciplinary proceeding tribunals. D. All of them. So right is the all of them. The relevancy of the fact forming part of the same transaction is dealt under which of the following section of the Indian Evidence Act? Section 4, 6, 10 and 8. Right answer is the section 6, which talk about the relevancy. Now the 99, section 31 of Evidence Act declares, what declares? Let's see. A. That the admission are not conclusive proof of the matter admitted, but they may operate as estoppel. B. Unless the admission are the contractual or unless they constitute estoppel, they are not conclusive but are open rebuttal or explanation. C. Either A or B, and D. Both A and B. Right answer is the D. Both A and B. 100. The defense of alibi is best because A. If the accused was not there when the deceased was murdered, he could not have murdered her. B. Once the police alibi is raised on the other defense is open to the prosecution, it leaves room for no other defense for the accused and none of them. Answer is the A. 101. Which of the following is the way to access damage under section 12 of Evidence Act? So we have another again 4 conditions. 1. Damage suffered should be near as possible to the sum which will put injured party in the same position as he would have been if he had not sustained the wrong for which he was awarded damages or compensation. 2. Damages are usually assessed on the basis of the actual loss suffered and are called general or ordinary damage. 3. When the plaintiff has not suffered any real damage by reason of breach of contract, normally nominal damage are awarded. And 4. Special damage can be awarded for personal inconveniences or physical discomfort caused by the other party. Right answer is the D. All of the above. All the conditions are correct. 102. Principle on which the dying declaration is admitted is evidence. In evidence is indicated in the legal maxim. It means that dying declaration equal to which legal maxim? A. Nemo moritus prosemitris menitri lex fori res judicata, none of them. Answer is the Nemo mitrus prosemitri menitri. 103. The proviso of the Section 65 Indian Evidence Act has been added by the which of the following act? So the right options are Act 31 of 1926, Act 22 of the 1926, Act 13 of the 1926, and Act 14 of the 1926. Right answer is the A, Act 31 of the 1926. 104. To invoke the doctrine of the estoppel, which of the following condition must be satisfied? Doctrine of the estoppel. A. Representation by a person to another. B. The other shall have acted upon the said representation. C. The such person shall have been detrimental to the interest of the person to whom the representation has been made, and D. All of them. Right answer is the D. All of them. 105. Under Section 82 of the Evidence Act, the court must presume A. That the seal or stamp or signature is genuine. B. That the person signing the document held at the time when he signed the judicial or the official character he claimed. C. Both A and B. None of them. Right answer is D. C. Both A and B. 106. What is direct evidence? Conditions are evidence given where the witness testify directly of his own knowledge as to main fact or fact in dispute. 2. That which tends to prove the fact at issue without the intervention of proof of any other fact. 3. One requiring no support by other evidence. And 4. When the principal fact or the factum probandum is attested directly by witness, things or document. So answer is the all the conditions are correct in respect of the direct evidence. 107. Which of the following are true for Section 27 of the Indian Evidence Act? Let's see all the four conditions. There must be information. 1. 2. It does not matter whether the information amount to confession or not. 3. That the person must be whether the information amounts to confession or not. And 3. In consequence of the information, a fact must be deposed to as discovered. And 5. In such a case, so much of the information as relates distinctly to the fact thereby discovered may be proved. So answer is the all of them. All the conditions are true for the under Section 27. Now 108. Which of the following is true concerning the retracted confession? A. It is the law that once confession is retracted, the court should presume that it was tainted and be thrown overboard. B. The retracted confession of co-accused is very weak, and if retracted, the same is admissible against the maker of it. C. The court is bound to take the factum of retraction of confession. And D. Retracted confession must be looked upon with lesser concern. So right answer is the C. The court is bound to take the factum of retraction of confession. 109. Which class of the person does Section 18 Indian Evidence Act lies down who can make admission? A. Party of the proceeding. B. Agent authority by party authorized by the party. C. Third, party suing or sued in representative character making admissible while holding such character. And 4. Person who has any proprietary or pecuniary interest in the subject matter of the proceeding during the continuation of the such interest. And 5. Person from whom the parties to the suit have derived their interest in the subject matter of the suit during the continuance of such interest. So again it is saying that all of them, all the conditions are true with the relation of the admission. Now the last question, question number 110. Section of the Evidence Act deal with the admission by person from whom interest is derived. Section 12, 16, 13 and 18. It is the D section 18. Okay friends. So these were the set of 110 question we solved in 3 videos. It is be very beneficial for you to go one by one and listen them very slowly and then appear in an exam. So friends, I'm again last requesting you to please like our this video, subscribe our channel and share this video. Thank you very much.